Members of council, if you could please be seated. All right. Good evening, everyone. Welcome to tonight's City Council regular meeting for Monday, March 2nd. We have 2 agenda items up for tonight. Up first is our City Attorney Tamara Niles, here to provide information on a proposed Municipal Code amendment to provide a comprehensive, clear process for contested hearing. Good evening, City Attorney. Yeah, I was gonna say, it was like, it's the wrong one, isn't it? We might have to go to the agenda to get it stopped. I was gonna say the agenda item does have the right presentation. So let's take Title 1, Chapter 10 on there. Okay. Yeah, I was gonna say the agenda has the correct item, so
This item got moved around a bit on the agenda. I found a gap and it was added back into this agenda at the last minute, so I suspect it's in a different.
all right. See, what it was is we were just waiting for Steve. That's what it was. So had nothing to do with the fact that we didn't have the right agenda up. We were waiting for Steve. All right, I think we should be good to go, at least for members of the public. Yeah.
Okay, perfect.
All right, go ahead, City Attorney Niles, when you are ready.
Okay, thank you, Mayor. Tonight we're presenting on a potential change to Municipal Code for a comprehensive hearings code. So this aligns with our code cleanup project, and that we're trying to bring clarity and consistency to Municipal Code. So both people that preside over administrative and quasi-judicial hearings and those attending them and requesting them all clearly know what the rules are, and they all follow the same rules. So this first came up during, I believe it was a study session, or perhaps it was council member choice, where Council or Mayor Pro Tem Anderson suggested that we needed this in our code because there were some differing provisions in different sections of code. So this proposed code amendment arose out of that council request. Next slide, please. So this just lays out all the hearings that we have. Of course, City Council presides over quasi-judicial hearings, but we do have hearings that are presided over by P&Z, Planning and Zoning, BOAA, the Historic Preservation Commission, and also we have administrative hearing officers, independent hearing officers that are appointed by City Council that also preside over hearings. Most commonly, we've seen lately in trespass, ejection, and exclusion proceedings, where somebody violates a city rule or city code, and they're given a form that says they can't come back to the library for 90 days, something like that. They can request a hearing, and then an administrative hearing officer determines if that will be upheld or not. So if you go to the next slide, these are the municipal code sections that specifically require independent hearing officers to preside over hearings. So I wanted to make sure you knew exactly what hearings we're talking about. Next slide, please. So I wanted to just provide for you a recap of the proposed code amendments. We do have a draft ordinance in your packet as well that lays out every one. I did not include in here the ones that are simply cleanup, that maybe we worded it a little bit different to align with our current style guide, things like that. So these are the substantive changes that I wanted to highlight. Kind of a cleanup, we clarify that any city employee or hearing officer can serve a notice of hearing. So, for example, if my office is issuing the notice, we can email it or hand deliver it, or whatever service they designate, which is in the bottom point there, the method of service. Or the hearing officer, for example, can issue and serve the notice of hearing. We also aligned our code to follow state law that a registered agent, which is through the Secretary of State's annual report filing and designation of a registered agent, that is a person that we could serve for a notice of hearing. So that was just a cleanup to align with best practice under state law. Next slide, please. We made it clear that these hearing rules also apply to independent hearing officers. That was an ambiguity in existing code, and that they apply to both administrative and quasi-judicial hearings, and that they apply to all hearings unless a specific section of code says otherwise. So the proposed code amendments in your packet, you can see there's a lot of strike through from specific code sections. For example, sales tax challenge hearings. It has significant code provisions on requesting a hearing and the conduct of the hearing. So we have taken that out and instead referred to this new title that applies. But if we've left something in, it's because that department determined that specific hearing needed something different, perhaps a little bit longer for a hearing or a little bit longer to issue the order, something like that. So we also added in a lawsuit, if you don't raise an issue at the beginning, you waive it. And so we've added that if they don't raise an issue, whether something is an administrative hearing or quasi-judicial hearing at the beginning of a hearing, so that the hearing officer can make that determination, then you waive it. So it's a required beginning of a hearing thing, which is the same thing we have to do in litigation. We also clarify that all notice of hearings and appeals must be filed with the city clerk. Right now, we have a code provision that says a request for a hearing for a vehicle tow has to be filed with the municipal court. So that was really an issue that started this project. They called me when they got one and said, "What do we do with this?" I was like, "I don't know. Give it to me, and we'll figure it out." So that was kind of the impetus for this project. We also included that any required filing fee shall accompany a notice of appeal. And of course, City Council sets those fees, and you've decided not to set a fee for the time being, but we wanted to make it clear if you do set one, it has to be filed with the notice. And then they have to make certifications too, that are the same certifications you have to make when you file a lawsuit, which is it's not for an improper, it says person, but not for an improper reason. The claims have a factual basis, etc. We also wanted to clarify some timelines. Under current code, the municipal clerk has a very short period of time to find a hearing officer willing to hold a hearing on that subject matter, and the hearing also had to be within a very short period of time. And we found that just wasn't reasonable to be able to find somebody and schedule a hearing and get all that done. So we proposed to amend that so that the clerk has 10 business days to find a hearing officer willing to hear the matter and to refer the matter to them. Then the hearing body issues the notices regarding the matter. This is also an issue. Like at that point, does the clerk have to issue a notice of hearing? Does the hearing officer? We wanted to make it clear the hearing officer does that. The clerk doesn't need to be their administrative assistant. And also the hearing body then, which the hearing body is also defined as the hearing officer, has 30 days to set a hearing and then 60 days thereafter to hold a hearing. And you may think, oh, in an exclusion, I mean, that's 90 days right there, which would be the period of time of exclusion. For those exclusion hearings, it stayed while this is pending appeal. So we just found it wasn't enough time. The parties were all having to agree to extend the time that was in code. So this just makes it much easier to provide a reasonable timeline from the beginning. Okay, these are kind of short now on the screen, so I'm going to lean forward a little bit. We also provide, again, we're trying to align it a little bit with best practices in litigation, that witnesses, instead of an oath that they may have an objection to, can also make a solemn statement that the testimony they're about to give is the truth, the whole truth, and nothing but the truth. Clarifies that we can record by audio or video, because that's not currently clear. Also, we will specifically propose that the hearing officer can issue a verbal opinion at the end of a hearing. Right now, it requires it to be in writing, even if it's a very simple issue. And of course, the city pays for that, and perhaps the hearing officer knows at the end of a hearing, no, your argument doesn't have a legal basis, or I'm ruling for you. So it makes a faster resolution and a less expensive resolution for the city. We also provide in there specifically that if there is a body that, such as P&Z or City Council, that needs to deliberate on a quasi-judicial matter, you can do so in a closed proceeding, which is allowed under the open meetings law. We've also had come up several times from different hearing officers, what's the burden of proof? Who has to establish what and by what standard? And so we have argued, and several hearing officers have agreed, that the burden of proof is a preponderance of the evidence. So we propose, let's just put it in there so we don't have to brief it every time we have a new hearing officer. And there's also an assumption that the hearings will be virtual, so via Teams or Zoom, which is also easy for the hearing officer to record, unless someone requests an in-person hearing. So if someone requests an in-person hearing, then it will be held in person. Actually, could you scroll back up? I think there's a couple other things I wanted to touch on. Also, there's not a clear provision for when someone can request a continuance. So we wanted to make it clear if the hearing officer sets a date, and either the city or the person impacted that requested the hearing, if that doesn't work, that the hearing officer will grant a continuance for up to 10 days. Because our purpose is to make sure everyone has their hearing and their due process rights are respected. Okay, next one, please. This is one that I really wanted to draw to your attention because it is a substantive change that we don't currently do at all. We looked at the costs of hearings to the city, and I believe the numbers were somewhere between $1,200 and $10,000 for a very in-depth hearing. And what we saw is even if the city won, even if the hearing officer determined, no, this doesn't have any basis and we're upholding the city staff's decision, there's no way for us to get reimbursed. There's no filing fee. So we wrote in there that the hearing officer does have authority to reimburse the city's costs up to $500. It's not required, but it recognizes that the hearing officer does have discretion if they think that's appropriate. So I wanted to draw that to your attention. It does require a hearing. And so we would have to present evidence as to why it would be appropriate for the hearing officer to do that. In addition, I aligned this with litigation, that if it was filed for an improper purpose, if the hearing officer finds that this never should have been filed, the purpose of filing it was to harass city staff, or they knew it was completely lacked a basis, but they did it anyway, they had some improper motive, this would give the hearing officer the authority to reimburse the city of all of its costs and to order the person that requested the hearing to pay it if they had an improper motivation for filing. So something to think about, but it would align with litigation because judges have that same authority for that improper purpose. Finally, it again aligns with a hearing in front of a judge that you must pay a witness fee and mileage if you subpoena someone to testify. If you require them to miss work and testify on your behalf at a hearing, then you have to pay a witness fee and mileage. And then this is the cleanup. We had code provisions that were different in all of these sections regarding all of these various hearings. So this would eliminate the ones that are duplicative and refers back to this new comprehensive, consistent, clear code. And I believe that is it. This is for study session. I think next steps would be you give me your direction tonight. And if you want to proceed, then we would bring it for consideration at a future meeting.
Sounds great. City Attorney Niles, thank you very much for the presentation. Any questions from council? Member Ward, go ahead and kick us off.
The one thing that I was curious about is the written decision requirement. If one does not have a written decision, how does one form an appeal to the district court?
So it would be recording. The hearing would be recorded. I think in that case, the notice of appeal, which we anticipate we would create forms whenever possible, because our goal is to make this easier for everybody. But so I think if they do file a notice of appeal, it may have to be reduced to writing, but it's not necessarily required that it be in writing to appeal it. The appeal would be the final decision, not necessarily a piece of paper. But I do think we are required to record it, and so we could create a written record from that if necessary.
I guess I'm in general not opposed to having a hearing officer deliver a verbal verdict in the immediate, but even just a one sentence statement that says, we had the hearing on this date and we found that the decision of the city was sustained or reversed would be satisfactory for me. In my experience, the court likes to see that an official action was actually taken before a court action is initiated. So that would be helpful for me if I was, for instance, litigating something like this pro se.
Thank you, Member Ward. Any further questions from members of council? Go ahead, Member Russell.
Thank you, and thank you, City Attorney, for the presentation. I do have a question. You said a few times that a lot of this is aligned with litigation. And so, I mean, a lot of hearing things that we're hearing that people are going to be called in for nuisance and different things. Are they expected to get an attorney? Because I wouldn't understand all of this.
No, in fact, and most people don't have attorneys in these proceedings. I didn't highlight it, but one of the small print in one of the slides said it is an informal proceeding, and we're not required to follow formal evidence standards or formal. The hearing officer can accept hearsay, for example, which is what somebody else told them. So. In general, though, it would be sometimes the city is represented by counsel. Sometimes it's my office that represents the city, but sometimes it's just maybe a code compliance officer and a property owner. And the hearing officer in that case, it's kind of like small claims court. The hearing officer says, "Okay, code compliance officer, tell me why we're here," and then, "Okay, property owner, what's your response?" And then they have the code, and they can ask questions back and forth.
And I guess some of my other concerns are a lot of these things, it seems like they were written in here to protect the city. And I mean, like for instance, if somebody wants a hearing to go after the city, what happens if the city wants to go after somebody? What protections are the citizens going to have? Because they're the ones that are probably going to be called before the hearing officer.
Yes. Well, first, I do represent the city. And so when I write code sections, it's generally to protect the city or to allow us to recover our costs, things like that. So I look at both protecting the city from a legal perspective, but also look at some operational issues because we've had kind of some budget woes on how are we going to pay for all of these hearing officers. So yes, you caught me on that. I do write things with protecting the city in mind. But I also write them to protect due process rights of our citizens and to ensure they get a fair shake, because that's obviously very important to my office and to you as well. Now I started talking on a tangent and I forgot the rest of your questions.
Well, I probably can't remember all of it either, but I just want to make sure that the people are represented. And the other question that I have, because I know this came up a couple of years ago, someone got a nuisance. There was a dead tree and they didn't cut it down, and so when they went before the hearing officer, the tree wasn't actually not on their property. According to the county records, it was outside their property line, but the hearing officer would not allow them to enter that into evidence in their defense. And so how are we going to protect people from that happening?
So we have provided a standard. Oh, and I remembered your question
Okay.
about retaliation. Would
Okay.
this? How could the city
Yes,
retaliate?
right.
So first, we've written in there what evidence should be admitted into a hearing, which it has to be probative. I mean, it has to be relevant. Um, and so, if a hearing officer doesn't allow evidence of something that meets the standard for admission, that would be a basis for appeal. So they could file a notice of appeal, take it to a district court judge. I mean, ideally that wouldn't happen, but that is a way their rights are protected. In addition, people do have rights depending on what the action is that the city staff is alleged to retaliate because of. It could be something they said, which could be a First Amendment protection, where we can't have an abuse of our discretion. We can't target people, and those could be a basis for a separate lawsuit specifically against the city. So that's what courts handle those types of claims.
Okay, and so I guess that is another one of my concerns, like to recoup the cost that this is costing us. We want to charge the people for that if they lose their case. Currently, we have a court system, and the court system is funded more itself. I mean, I know there are things like court costs. So is that ethical for us to do that? I mean, because this is not a court case. It is a hearing officer.
Yes, but it's called a quasi-judicial proceeding because there is a hearing officer that acts like a judge, and they take evidence and then they look at the law and they apply the evidence they received to the law and make a decision, just like a judge would. So there is nothing that ethically prohibits us from having some of those same provisions that say you can't request this hearing solely to harass city staff, for example. So there's no ethical concern from my perspective in aligning our quasi-judicial procedures a little bit more with those procedures that are required in court.
Well, and I'm kind of assuming that most judges have more experience and more training than a hearing officer would, correct? I mean, so these laws are written, I mean, well, this ordinance is written to help the hearing officer too, correct?
Yes. The hearing officers that you've appointed by resolution are generally all very, very experienced lawyers that have served in those capacities for years. So I'm sure there are some judges that have more experience, but the panel you have chosen are very experienced, and I would put their experience up there with any district court judge.
Okay, and just one other question. I mean, because I know that, and so is the council going to be given a list of people that we could appoint for hearing officers? I mean, we appoint a whole group of people, and then the city clerk chooses from those people that are appointed?
Yes. So you appoint them by resolution, and I believe you did in December. I think it was the end of last year that you last did that.
Okay.
And the hearing officers choose their areas of expertise or what they would agree to be appointed to preside over to align with their experience. The city clerks then go down the list and just try to find one that's available, willing to take on this matter. They have to make sure they don't have a conflict, for example. They've never maybe represented them or something, the person requesting hearing, something like that. So it can take some time, but they just go from the list that you have approved.
Okay. And I mean, have we compared with our court system at all? Because I know they have hearing officers there also in our court system. Would it cost us less money to use our court system than what this is going to cost us?
So we do already pay the overhead of the court system, but that was another impetus for this. We had understood at one point that the municipal court judge had presided over vehicle impoundment hearings, which is why we think the notice of hearing was filed there. And the court indicated to us that they were unable to do that anymore. So we were making the assumption that they're probably wouldn't be willing to consider expanding their duties to other administrative hearing matters if they weren't willing to consider ones that other judges in our municipal court have presided over in the past, which we completely understood. I don't want it to seem like we were questioned that decision at all. So we completely understood that position of the court.
Okay, I think for now, I just, sometimes when we hire and we pay the hearing officer, is there ever any pressure for them to decide in favor of the city?
Based on their rulings, I don't think they feel any pressure to rule in favor of the city at all.
Okay.
But we get our fair share of rulings against us. But we have tried to maintain that separation. That's why my office doesn't find the hearing officer and hire them, because my office often represents the city. So we want to make sure there is a separation, that they're not dealing with the same person to get their bill paid that is trying to convince them to rule one way or the other.
Okay, I appreciate that. Thank you.
Member Bethel.
I think that Member Russell makes a good point about how approachable this process is for the average citizen. I've seen some excellent flowcharts come out of your office. Would this be a good opportunity to create some flowcharts for people that are experiencing this process for the first time?
Yes, we do anticipate there would be a pretty short manual, because the requirements for them, for people requesting a hearing, are pretty minor. But we would anticipate, and we've already discussed, a standard form for them to fill out, so that it's just something they can pick up and fill out, or fill out online and submit. And then a short guide as to the process from there, what they can expect.
Great, thank you.
Member Prang.
Thank you. Thank you for the presentation. I think I largely get most of this, but I do have a few clarifying questions. Are there some actions that have a filing fee and other actions that don't?
I think currently nothing has a filing fee.
Okay.
Do you agree with me, City Clerk Carlisle? Okay, yeah, we don't think anything currently has a filing fee. There is a municipal code section that says the city can charge a filing fee, and we brought that to City Council to consider, and you decided not to set one. And so we just, to align with the code section that says a hearing fee could be charged, we wanted to reference that just to be consistent in case a future City Council decides to charge a fee. That structure is already in place like it currently is.
Okay. So there's just common understanding practice right now that we don't charge fees. Okay.
Yes, exactly. Now that said, some P&Z, if there's a land use matter, somebody's coming before P&Z and then City Council for a PUD, I'm assuming the developer has to pay some sort of fee to the city. But this doesn't change any of that. It doesn't create a fee. But other than that, I can't think of anything where a fee is currently being charged.
Okay. And then, so with the ability for the city to recoup its cost some, I'm just trying to get at like when and how it's decided if someone is trying to harass city staff. I just am trying to feel comfortable with some sort of common process or protections in place that would kind of indicate how to handle making that determination. Who makes that determination? Is it the assigned officer that's making that determination? And I just don't want the city to be at risk that we're being partial in any way to say, this one has merit, but this one doesn't. And this one has, more merit, and this one has less. So for this one, we're going to charge a full $500 to recoup our fees versus over here, we might be charging $50. Like, how do we have some balance and assurances that we're not creating more risk for ourselves as a city to apply this?
So it is the hearing officer that would make that determination. It would be an extreme case where the hearing officer would find that somebody filed an appeal for an improper purpose. I mean, It would be there. The city would have to produce evidence of that, and it would have to be clear evidence. And the other side would be given a chance to rebut that evidence. So I think hopefully that never happens. But if somebody does have an improper motive, if they just want to harass the city attorney for something, and they publicly stated that I'm doing this to harass the city attorney, even though I know this doesn't have merit and they'll rule against me, maybe that could be a basis. But again, it would be an evidentiary hearing where the city would present that and say they knew that they were going to lose, but they did this to personally harm a city employee. Something like that. I can't give you an example of any time that's ever happened, and hopefully it would never happen. I think the more likely scenario would be somebody files a notice of appeal. We pay $500 for the hearing officer to get ready for the hearing and to maybe appear in person if they requested an in-person hearing. And the city, an attorney for the city had to spend hours preparing. The city clerk's office had to spend hours organizing it and reserving and that sort of thing. And then the person doesn't show up. So in that case, their appeal would be dismissed, and then the city could make a motion for up to $500 in costs, at which case I anticipated we would set another hearing, and then the person would be given a chance to show up and say, I got in a car accident on the way there, so please, I don't think it would be just to award fees against me. I wanted to be here and something out of my control. In that case, I anticipate the hearing officer would not award any costs at all. But it would give them the discretion to be able to reimburse a portion of the city's costs.
Okay, that makes sense to me. And so it sounds like some of that determination is going to occur during the midst of the hearing, and both parties have their ability to present the whys.
Yes.
I just don't, I mean, I got tripped up a little bit reading through this, thinking, being able to request a hearing with the city, or, to kind of counter a decision that the city has made, then making statements that we can then, decide whether your action is even appropriate or not. Like, it almost on some level sends the message of don't question us, or is like could be interpreted as a deterrent. So whatever materials we produce, to Member Bethel's point and Member Russell's point, like for the layperson who's reading through this, just making clear that this is still your right as a resident that lives in Inglewood, and that, these things are possible, but, in every way that we can, this will be a fair process kind of message. I also had a question around disciplinary actions for employees. Can you tell me what is an authorized appeal against a disciplinary action, and is there an unauthorized appeal?
So you're talking about for the hearings that we specifically list?
Yeah, for HR related issues.
Yes, so that's currently for some union employees. They can request a hearing to challenge certain bases of disciplinary action.
Got it.
So that's subject to change. We've had some differing interpretations. It's only happened once in the 5 years I've been here where we had a hearing on that basis.
Okay, that makes sense.
And if it's not authorized, they don't get a hearing. We don't schedule it. So it has to be authorized either by admin policy or their union agreement.
Okay. My last question is, what is the definition of proven indigency? And if there is a definition of it, should it be included in the language of this?
I believe we left it undefined to give the hearing officer discretion. Courts generally have a standard, but I've seen it be flexibly applied, where a judge just says, do you have money to pay for this? And they say no, and then the judge pays for their attorney, things like that.
Mm-hmm.
So I specifically left it undefined so that the hearing officer could make that determination themselves. I would be happy to insert a clarifying definition of what that is.
I would feel more comfortable if there was, I don't know how specific we need to be, but some sort of language that defines what that is, just to, again, protect against any risk that we're not judiciously applying that language.
Mayor Pro Tem?
Thank you. And I don't have any questions, but just did want to thank you for working on this, and especially on account of I think it can be challenging to have to deal with the city government, especially if you're facing some kind of a hearing, and to just simplify it for citizens, streamline the process, make it really clear. I think is really important for the benefit of the citizens. So I do like all the suggestions on the documentation that we can produce to help everyone understand the process before they have to go through it. So thank you.
Thank you very much, Mayor Pro Tem. Member Ward, go ahead.
I want to circle back to the fee portion. This did grab my attention as well. I wonder, the federal court in particular has a process for what they label vexatious pro se litigants. I don't know what the exact terminology is, but any pro se party who files, a dozen cases in a year that are all deemed frivolous has to submit their filings to the clerk, who reviews them before they even see a judge. I'm wondering if we can adopt a somewhat similar process here, where if someone is known or has a history of filing vexatious administrative appeals, then we can charge them a fee prior to being heard, or we can charge a fee upon finding of the hearing officer that the appeal was frivolous or vexatious, similar to what the state court does.
We considered something like that. Two reasons why we didn't include it. Obviously, we're happy to insert that, but two reasons: we don't currently have anyone we consider vexatious, subject to change at any time. But that's also then why we wrote in the provision about reimbursing the city for its costs. If a hearing officer finds in one case that it was brought vexatiously, if they were a vexatious filer, then the city could be reimbursed for its full costs, which can be a deterrent for future action.
Okay.
And full costs, again, can be $1,200 to $10,000. It could be significant.
Yeah, generally speaking, I don't, particularly with municipal matters, favor charging a filing fee. I understand the impetus for it, but I think it tends to be a roadblock for people who just have a legitimate dispute with city government. I harken back to years back when there were some ballot initiatives and other things that, actions of council, like meeting an executive session, that I would have challenged, but it would have cost me $250 to file a court case, and so I didn't. And I would hate that to be a bar to due process when the city did something inappropriate that could otherwise be remedied.
All right. Anything else, members of council? I know we're running long on this item, but Member Russell, go ahead.
Thank you. So I have another question on Section 8, 15-5-1, vested rights and takings determination. And probably mostly in paragraph D, an application for a vested rights determination or takings determination shall be submitted to the city manager's designee in the form established by the city manager. If they think the city is taking something from them that they don't have the right of, going before the city manager's designee, isn't that perhaps a conflict of interest?
So we anticipate that those people would be the city clerk and an independent hearing officer. So we don't anticipate that our city manager, generally those provisions are for much smaller cities where the city manager has extra time to preside over a hearing. So we left that in because it's what's in code now, but we anticipate the city manager's designee is an independent hearing officer who has the time and expertise to preside over them, because I know the city manager doesn't want anyone to question whether he was fair and unbiased or not.
Right, and I appreciate that. I mean, I assumed it probably was not going to be the city manager. But in all fairness, the city clerk is hired and fired by the city manager. And so I just think some of these things we need to be very careful that it couldn't appear as though, or won't appear as though we have a conflict of interest.
All right. Thank you very much, Member Russell.
Thank you.
Anything else from members of council? I think all the input given tonight was good. I think, I guess from members of council, any disagreement based on the changes that we are requesting or based on the additional information, are we okay seeing this come forward in the future? All right, I think we're good. City Attorney Niles, thank you very much for the presentation. I think we're good. Thank you so much. All right, we're moving on to the second agenda item, and I do think that we're going to go over time on this one. Hopefully, we can kind of stick as close as we can to the 7 o'clock hour. But we have Affordable Housing Program Manager Seth Brown here to present an overview of the new state law concerning the right of first refusal. Good evening, Mr. Brown.
Good evening. I just wanted to make sure we get the right slides.
I think
up
we do have this one.
there.
It's not that
showing
one, but
something different
like
right now.
now.
It's a little out of my depth.
Should be the next one. There we go. Yep.
Okay, great. Well, thank you, Council. Tonight we'll be discussing House Bill 2024-1175, which gives local governments a new set of tools to help preserve affordable housing in our community when it comes up for sale. My clicker working. You go to next slide, please. Oh, here we go. Okay, so a summary of the two parts really of this bill. There's the right of first refusal, which allows the local government or an eligible assignee to make a matching offer to purchase an existing affordable housing property that has 5 or more units, and that's only if the owner chooses to sell. Next, we have the right of first offer, and this allows the local government or eligible assignee to express interest and make an initial offer to purchase an existing multifamily residential or mixed-use rental property that has 15 to 100 units prior to the property being listed for sale. The last piece of this is that there's partnerships and an assignment option. So the local government may partner with either a nonprofit, private, quasi-governmental, or other governmental entities to finance, lease, or manage these qualifying properties, and may assign the right of first refusal rights to this local, regional, or state housing authority on a property-specific or programmatic basis. Okay, so first up, for the right of first refusal, like we talked about before, it must be an existing affordable housing property that has at least 5 units or more, and the purchase cost and offer would need to be substantially identical to another offer that the seller receives. This right is not indefinite and would be terminated December 31st, 2029. So you can see here this flow chart. This is just trying to look at the process in more simple terms on what decisions are made throughout. So you can see this is triggered when the owner decides to sell and receives an offer they are willing to accept. Again, this is for an affordable property with 5 units or more. The owner would then notify the city, letting the city have a chance to make a matching offer within 30 days or less. From there, there's the 2 options. The city could choose not to make a matching offer, in which case the sale would proceed normally with the original buyer. If the city does choose to make a matching offer, the owner then has the choice to either accept or reject the city's matching offer in that 14-day timeline. If the owner does not accept, they can reject and explain why. This would invite the chance for the city to counter offer on the seller's terms. And if no, then the sale again proceeds normally with the original buyer. If the owner does accept the city's matching offer, then it would move forward with executing a contract in 30 days or less and closing within 60 days after that contract. And that closing and contract execution mirrors a typical multifamily closing timeline of 60 to 90 days. Next, for the right of first offer, again, this is any property with not more than 100 units and not less than 15 units, but it can be market rate. So sellers must first notify the city or appointee of the intent to sell prior to putting the property on the market. Again, this is not an indefinite right. It's terminated December 31st, 2029. The flow chart for the right of first offer process. This is also triggered if the owner decides to sell and receives an offer they are willing to accept. The seller notifies the city prior to listing. So this is the early notice where the city can review, and if the city chooses to request interest, there is a voluntary conversation that can happen between the owner, seller, and the city. During this time, the owner may continue to market the property and may either accept or decline the city's conversation or offer. There's no obligation to sell. If the city does not request interest, again, the owner continues to market the property. And in this right of first offer process, there's no required waiting periods. The owner may proceed normally. So in conclusion, this law provides two voluntary market-based tools that give local governments an opportunity to either preserve existing affordable housing with the right of first refusal or prevent the loss of affordability when a property changes hands for the right of first offer. Again, this is while maintaining the owner or seller choice to, if they choose to sell to the city and closely follows the market timelines. Council has multiple options for how to utilize this law, whether that's maintaining these rights for the city, transferring these rights entirely to our housing authority, innovative housing concepts, or partnering with the housing authority and approaching these opportunities on more of a case-by-case basis. Are there any questions? And because this is a study session, would appreciate council's direction on additional direction just from council on whether to pursue this further.
Sounds great. Mr. Brown, thank you very much for the presentation. Any questions for members of council? Go ahead, Mayor Pro Tem.
Now, thank you for the presentation. The question I have is, does this, you said it only applies to affordable units, five or affordable apartments with 5 or more units. Are those specifically, designated affordable units by HUD, or we're talking about, market affordability as well?
Correct. So this is income restricted,
Okay.
and that's for the right of first refusal. There were the two paths. Right of first offer is at 15 to 100.
Okay.
That can be
any
market rate. It's just when it's changing hands, but the
gotcha.
timeline looks a little different. It's trying to hopefully clear up that distinction between the two flow charts.
Now, this isn't this. I think we've had a discussion on this before, maybe.
Yes, I should have started with that. I know this was discussed, I believe, in 2024, and bringing it up again just to seek direction from you all on if this is something we should pursue.
I'll let others weigh in. I have thoughts as well, but for now, I'll leave it with just a question.
All right, thank you very much, Mayor Pro Tem. Any further questions? I guess I'll ask a couple of questions, I believe. So I know you mentioned the Inglewood Housing Authority primarily as one of the options in terms of who we can work with in these two instances. Are there any others? Because they do list out nonprofits and a couple of other items. Is there anyone else that you would foresee that the city would partner with in any of these two cases?
So they do list that as there's some flexibility. I will say, given their positioning and the work that is already done, I believe that if we were to transfer those rights, the housing authority would make the most sense, but there's options that we could look into if they're.
I was just wondering if we highlighted some others internally potentially for this. So, and then secondly, regarding the right of first refusal with the properties that are 5 or more, are there any properties within Inglewood that fall under this umbrella?
Yes, there are, and could put together a list. The one exemption, there's quite a few exemptions actually built in. A big one is if the property is under 30 years old, this does not apply. So it's mostly looking at older housing stock. But there's a couple properties that it would apply to if they ever were to come online for sale in the future.
Okay. I'm trying to think. So how many properties are under 5 that fall outside of this law? That potentially, or have we calculated that? Because I remember having a conversation about this in the past with Lindsay was primarily at HA, and I think the biggest bang for their buck would have been for properties under 5, but because they were exempted, she didn't foresee this being. Well, it's still a benefit, but not as much as it would have been if it would have been under 5 units. I
Correct.
think that's the
And
best way to say it.
yeah, that is a good distinction that the House bill states that it only applies to 5 and over. It doesn't reach down to those smaller two unit properties like you're mentioning would not apply to this.
All right. Member Prang, go ahead.
Thank you. Thank you for the presentation. I have one really simple question and then one that you can have some fun with. Why do these two provisions within the legislation sunset in 29? Is there like an assumption that by then we will have gotten some movement on affordable housing and so it's no longer needed?
I believe it was mostly intended so it's not an indefinite right that cities are granted. Even, it's a tool that cities may choose to use or not, but it also will not go on forever. So that's the way that they set it up, is it's not an indefinite going forward, and it will wrap up at the end of 2029.
That makes sense to me. Sorry.
Mm-hmm.
I guess that also, I want to ask another question just for like clarifying to the public and so that it's like on record and clear. I did hear you say that this is completely voluntary.
Correct.
So if an owner chooses to sell, these are some options that are in place were we as a municipality to adopt these laws or choose to adhere to these state laws.
Correct. And the voluntary piece, the requirement would be to notify the city and the timelines that I laid out, but the city's right to opt in is voluntary.
Okay. The only other area for me that I would love to understand better is this definition of long-term affordable housing.
Mm-hmm.
And I'm happy to read that section out. And then I would love for you to just tell me what all of the pieces of it mean. And if it's possible, like within this definition, to kind of put a number to that for Inglewood. So in there it says long-term affordable housing is defined as the annual rent for any unit will not exceed the rent for households of a given size at the applicable area median income for a minimum of 40 years. And the local government agrees not to raise rent for any unit by more than the bill's specified rent increase cap. Could you say that in layperson's terms for us so that we understand what that means?
Definitely. So the area median income term is looking in Inglewood, what are the income averages? They set percentages for that. So 100% of the area median income would mean you're making average of what that income is. And then they look at affordability based on relative to the AMI of the region. So there's a lot of charts. It varies based on household size. If you are a family of 4 versus an individual, those numbers look different. But they're all set by HUD. And what was your follow-up question? Was
so
like
all
a
of these
ballpark
words
number?
essentially follow like the HUD's definition of affordable.
Yes, correct.
Okay. And what is the bill's specified rent increase cap?
Can you say that one more time?
At the end of the definition, it says that the local government agrees not to raise rent for any unit by more than the bill's specified rent increase cap.
I can check with our staff to make
That's
sure I give
okay.
a correct answer on that, but
Yeah, if you could shoot that information, maybe to city manager to send out to us or something like that
absolutely.
as follow-up. I'm
Yep.
just curious what that actually means. I appreciate your answers on that. Thank you.
Member Ward.
Can we go back to the flow chart? I looked in my packet and I didn't find it. So
Yeah.
it was a little confusing.
Would you like to do
This
I
one.
guess we'll start with
That one.
right of first refusal.
So, as I understand right of first refusal, it means there's a transaction that's going to occur between two parties. and a third party enters that transaction and says, no, that's mine, here's your money. That's not what's described in this flowchart.
So this flowchart lays out the process of if once the owner receives an offer that they are planning to accept for right of first refusal, if they receive an offer that they're okay with on those economic terms, they would then be required to notify the city that they have an offer that they're planning to accept, and then the city would have to substantially match that offer.
Right, but then the flowchart has two directions it goes.
Yes.
As I understand right of refusal, there would only be one direction, which would be city buys property after matching owner. But this seems to indicate that the owner can now refuse and sell it to the private party anyway.
That's correct. So at no point the seller is never forced to sell to the city.
Okay.
If the city makes a substantially identical offer on economic terms, then the seller must negotiate in good faith, but they can still decline that offer if they choose to. And so the choice of does the owner accept the city's matching offer, that 14-day window that's up there, if the owner says, no, I do not want to accept this offer, they can reject. And there's a requirement that they have to explain why they're rejecting the city's offer and invite a chance for the city to counteroffer and match whatever those terms are. But at no point are they forced to sell, and they're able to maintain their rights throughout the process.
So I might be viewing this in an overly simplified way, but I kind of leaves me with the question, what's the point? The typical process for selling a property is you list the property and someone who's interested in buying it makes you an offer. And if you can come to agreement on what that offer is, the transaction closes and you have a mutually agreeable transaction. Injecting the city in to the process, we now enter this bureaucratic quagmire wherein the transaction, which may have closed in 3 days, now takes 30 plus days to close because the city has to decide whether or not it wants to play ball with the owner. And the owner may fully intend to refuse the offer from the get-go, but he still can't close the property until after the city has had its pound of flesh, so to speak.
Yeah. So to answer your question on what is the point, this is when the property that's being up for sale is an affordable project. Let's say they're selling it to a market rate developer that would be looking to develop, like luxury apartments or something like that. It would notify the city before that property changes hands and give them a chance to match the offer versus finding out after the fact. So this is more a preservation tool when the properties are changing hands than the city being able to put in a lowball offer that somebody's forced to accept. That's not what this law does or bill.
That distinction is important, but I've still got some struggles myself on this, and it could just be a philosophical thing. I won't belabor it any further. Thank you.
Mayor Pro Tem and then Member Bethel.
I just thought I'd weigh in. I agree more or less with Member Ward on this. I don't think this actually benefits the city. If somebody puts a property on the market and the city wants it, we can go bid on it. If somebody tries to do a private sale without putting it on the market, they shouldn't be obligated to go to the city to see if the city wants to buy it anyway. Kind of puts the onus back on the property owner to keep the city in the loop. And I do know when these properties sell, they do tend to check with the city and the housing authority to see if they're interested anyway, because that could be a potential easy buyer without having to go to the market. And sometimes there are contingencies on these things, so they have to keep it affordable anyway. But I do think that this adds another bureaucratic tangle that lowers a buyer's conviction that this thing is going to get to closing, which probably lowers their price too. So I do think it has a negative impact on the ability to sell a property for its full market value.
Thank you very much, Mayor Pro Tem. Member Bethel.
Yeah, from my perspective, I think this provides a layer of transparency for the city that normally you wouldn't get in a real estate transaction, right? If you're buying a house, you put in your offer and you don't necessarily know what the competition's offer is going to be. That's they keep it that way so that it drives the price up. In this case, the city has the advantage of knowing what the market rate is and has the ability to match that. So it doesn't bring it down, but they know where it would sell at a private value. And then we have the opportunity to match that. So I don't necessarily think that it's going to drive the values down, but I do think it gives the city an opportunity to respond to what the market conditions are. I think it's fairly well constructed and would be a good tool if we choose to own any properties of that style.
Thank you very much, Member Bethel. Member Prang?
Thank you. I tend to agree with much of what Member Bethel just said. And I also feel that we continue to talk about affordable housing in the city of Inglewood, yet we continue to not actually put any teeth or anything into place to actually ever get at any level of affordable housing. So while I'm not a fan of the whole slate of legislation that came through in 24 on land use, this one I think makes sense, and it doesn't seem overly burdensome to a seller. And I do like that the process is a voluntary one.
Thank you very much, Member Prang. I agree. I think I wish the bill's not perfect. I wish it had a bit more teeth on this. I'm in favor of what it's looking to accomplish. And one of my worries I do have is the fact that, as Member Prang stated, we are talking about affordability within the city. I'd hate for us to take a step back in the number of units that are available within the city. I think this bill is allowing us the opportunity at least to have visibility of any upcoming properties that may be coming up to market in that time, and gives us an opportunity. That's it. It doesn't really infringe on the rights of the property owner themselves, but it gives us the option of at least putting in an offer. And whether or not the 30 days or whatever it happens to be is enough time for us to make an offer, something that I kind of question, but it's giving us time. So it gives us a chance, and I would be happy to see this move forward in the future to see if this is something that we can put in place. Member Russell?
Thank you. I tend to agree with Member Ward and the Mayor Pro Tem. And my question is, if something became available, really, would we as the city have an opportunity? I mean, perhaps the housing authority might, but as far as the city, our budget is already set for this year, and we might not be able to come up with the money. So I think that might be problematic.
Yeah, Member Russell, in this case, I think we're expecting the housing authority to be the ultimate, not necessarily the city for the reasons that you stated.
Okay.
And we really don't want to be property owners. So
Well, right, exactly.
that's the other aspect of it. So,
Right. Right. Thank you.
But thank you, Member Russell. City Manager Lewis, I see your light on.
Thank you, Mayor. I just want to make sure that council knows that this is already a requirement of property owners. So it's not, so taking advantage of the tool doesn't necessarily add a bunch of time or bureaucracy, because we're already receiving these because state property owners are required by the state within these guidelines that Seth laid out to notify us. So we've already received these and said, we're not interested because council hasn't taken advantage of this tool. So it's going to happen whether you take action on it or not. It's just a matter of, do we have, Seth, correct me if I'm wrong, do we have authorization to take that, any further?
Yeah, that's correct. Thanks for that distinction.
Okay. Thank you very much, City Manager Lewis. Go ahead, Member Ward.
But if we choose not to adopt the process, aren't we all putting all property owners within our city limits on notice that they don't have to cooperate with this bureaucratic system? Like, wouldn't every title company know that they could close in 10 days if they wanted to, because the city of Inglewood doesn't exercise its right to refusal based on council direction?
I hear what you're saying, and Sean, correct me if I'm wrong, but this is my understanding was that if we reject the tools, that it would be what Member Ward is saying, or is that your understanding?
I apologize. I'm communicating with Director Power in the back about this. I'm not sure exactly how that works, but right now we still have those. Actually, Brad, you may want to come up, but Brad is saying that's incorrect. Property owners are obliged to follow state law regardless of any action taken by the local council. So it would not necessarily delay a sale.
Director Power, do you have anything to add on this?
Good evening, Mayor, members of council. Yes, property owners that meet the requirements that are specified in the state law for the sale are required to notify us. And we've received a couple of those prior to any council direction specifically on what to do with this process. So as those come in, we have two choices. One is we could circulate them to you as an FYI basis. And if you are interested in pursuing them, we have a very short window to turn around, but we could technically engage the property owner at that. Or if not, we could just inform them or let the 30 days expire and then they proceed with their sale. I think the question is to whom do those notices go to? And that's one of the choices that Seth laid out, which is either remain with the city right now, or one of the options was the housing authority, which typically engages in real estate transactions for affordability. And that might be a more direct relationship with some of these property owners if the housing authority had the ability to acquire properties down the road.
So Director Power, the way that I understand it, based on the question that Member Ward stated, right now the notification is going to the city, but because we haven't given direction on this, it's basically dying on the vine right now because we don't have the we haven't given direction on that. So you're
correct.
So I think to Member Ward's point, I think because we haven't given direction, it's not going any further within the city of Inglewood.
Right, we will still receive the notices.
But we're not taking an action, which
That's
is
correct. So
what-
then the property owners
Yeah.
can engage in the private sector transactions.
So I think in
that
a
they've
sense,
done.
because we haven't given action, it's basically, there's no notification being given to the Inglewood Housing Authority because that's ultimately who would be making the purchase.
I did have a conversation with the former director of the housing authority when one came in to us, I believe last fall, and I don't know where that went. Obviously, those properties are transacted privately.
Okay. Go ahead, Member Ward.
I just want to clarify the question a little bit. So we have a state law that prescribes this right of first refusal process, but we also have home rule in Inglewood. And I don't know for sure, and I may need a legal opinion on this, whether home rule would apply to this. But if we were to, for instance, pass an ordinance that says the city of Inglewood does not exercise the right of first refusal in any way, shape, or form, in theory, based on what I'm seeing here, we would be automatically declining these. We may still receive the notices, but the property owners would be on notice that they don't have to wait 30 days to close a multifamily transaction like they do now, because the city has a window of 30 days to refuse. We're actively refusing all properties as standing law under my scenario, which would mean that they could close sooner if they wanted to.
I'll ask the city attorney to respond to the legal aspects of it, but I do recall that the two that we received, the proposed closing dates were substantially later than the 30 days. So that 30 days would have expired prior to their closing in those specific instances.
Okay.
Are we waiting for the?
I can
city
wait. I
attorney
mean,
now?
I can give you time to provide an analysis, but if this does come up for specific council action, I would like to know the answer to that question ahead of time.
One maybe point to add too is with those timelines, many of these steps can run concurrently with due diligence that would be happening anyways, and it shows those days, but they could still be running with their regular due diligence on whatever offer they had received.
And I'm also hearing tonight that we're probably at a 3-3 deadlock on this item. So based on the three options, but I may be mistaken. Go ahead, Mayor Pro Tem.
Yeah, I think we are, but I do want to say, like, can we just provide an automatic response to those that we reject? We aren't going to, that way they know they can move on with their process before the 30 days elapses.
Yes, we don't have to wait the full 30 days if
Just
we
reject it and
choose to immediately.
That's what I would want to do. If we're not going to do this, then we should just let them go on with their lives.
I think
Actually,
we're
do you
going to
mind
be
if I
deadlocked
jump
3-3
in
on
here?
that too.
Just to jump in here, I wouldn't use that type of terminology just because we're still awaiting a seventh member. I think overall, it's like city council has not made a decision on which action to take regarding the three. That would be my preferred messaging at the time. But go ahead.
The only rejoinder to the questions that you asked, Mayor Pro Tem Anderson, is whether or not you would like to be informed when those notices come in, or do you just want to leave it at the staff level that at this point, I don't think we have the several $1 million it would take to acquire a lot of these properties at hand. And so that's a question for the city council about what level of information do you need, or do you want to have this be administrative, at least for the foreseeable future, that our go-to position would be that we wouldn't engage in these discussions, and we would notify them of that immediately upon receipt of it.
Do you mind if I chime in on that? The only thing that I would, just as simple as just knowing that this comes up, so if it could be part of the Friday's report, or if there were 2 instances, just giving us notification through the Friday's report would be enough for me. So, Member Bethel, anything else? No. Anything else from members of council? I think that this is an item that we are unfortunately going to have to push until we get a 7th member. At this time, we're just deadlocked. So I don't see any further questions from members of council. So with that, Mr. Brown, thank you very much for the presentation. Thank you very much, Director Power,
Thank you for your
as
time.
well for the additional information. Members of council, do we need a 5-minute break? 5? Let's take a 5-minute break and then we'll kick off the meeting at 7:15. Thank you, everyone. All right, members of the public, we are now back. I call this meeting to order. If you're able to do so, please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. City Clerk, you could please take roll call.
Yes, good evening. Mayor Pro Tem Anderson,
Present?
Member Bethel,
Present.
Member Prang,
Present?
Member Russell,
Present.
Member Ward,
Present.
Mayor Sierra.
Present.
6 members present.
Thank you. Moving on to consideration of minutes from the previous session. Any changes to the minutes from the February 17th regular city council meeting? Seeing none, can I get a motion to approve the minutes from the February 17th meeting?
So moved.
Thank you very much, Member Prang. Could I get a second?
Second?
Thank you, Mayor Pro Tem. Can we please vote?
Mayor Pro Tem Anderson,
Aye.
Member Bethel,
Aye.
Member Prang,
Aye.
Member Russell,
Aye.
Member Ward,
Aye.
Mayor Sierra.
Aye.
Let the record show 6 ayes.
Perfect. Moving on to recognitions, we have 2 tonight. I think Director Rochelle, are you giving the introduction of our new Deputy Director of Engineering and Asset Management, Ryan Crum?
Yeah, thank you, Mayor. Good afternoon, City Council. Victor Rochelle, Director of Public Works. Tonight, we're excited to introduce our new Deputy Director of Engineering and Asset Management, Ryan Crum. Ryan Crum comes to us from Denver, specifically DOTI, Denver's Department of Transportation and Infrastructure. He started with us in late January. He has over 17 years of engineering experience in the field. Of those, 11 managing staff and projects, large projects. He's a licensed professional engineer in the state of Colorado. He's also design build certified. That's a DBIA, and he's also LEED certified, which is Leadership in Energy and Environmental Design, which is important as we continue to implement those types of infrastructure initiatives within the city as we advance projects. So with that, yeah, I'd like to introduce Ryan Crum. Thank you. You'd like to say?
Good evening, Mr. Crum.
Good evening, Council and Mayor. Just say welcome. Thank you for this opportunity. Continue to build on the good work here. I'm excited to lead and continue. So thank you.
I appreciate it. Looking forward to working with you, Deputy Director Crum. I'm not sure if you're aware, if Victor let you know during the interview process, but we've been talking a lot about assets here within the city of Inglewood, so I'm sure we will be keeping you busy. But yeah, really appreciate you coming on board. Looking forward to working with you and seeing you speak here at council meetings here in the near future. So thank you very much and congratulations.
Likewise, thank you.
All right, moving on to the second agenda item, or excuse me, the second recognition. So Inglewood City Council would like to recognize the volunteers at the Inglewood Public Library for their outstanding commitment to public service. The volunteers are an integral part of the library's day-to-day workflow. In 2025, 20 volunteers spent over 750 hours assisting in the library. They spent 464 hours on shelving alone. Volunteers also contribute into a variety of programs such as home delivery and tech assist. The volunteers are a valuable part of the library team during peak times like summer reading. Volunteers provide vital help by processing books in and out of the library, hunting down missing items, and keeping shelves neat and dust-free. It's no exaggeration to say that we couldn't keep up without them. Volunteers help keep the library clean, organized, and welcoming for the entire community. Their diligence means that when a patron comes looking for an important book for research or a movie for the weekend, those items are exactly where they need to be. Patrons seeking assistance with technology like laptops and computers are greeted with friendly patient assistance, and patrons who have materials delivered enjoy bi-weekly phone chats with volunteers who help them place holds and select books to read. So please join me in thanking the Inglewood Public Library volunteers for their many contributions to the city of Inglewood and their entire community. I think we're going to read off each of the names, and also we have a certificate, and we'll take, I think, individual pictures and then a group picture as well. So if you want to read off the names, City Clerk Carlisle.
Rebecca Cherson. Sean Cunningham. Mark Elliott, and John Talbot.
Perfect. If all 4 of you would invite you up, we'll take a picture. There you go. Good. Perfect. All right, everyone. Let's see here. We are now moving on to recognition of public comment. We set aside 90 minutes for public comment tonight. Each resident is limited to 3 minutes. For those of you that have not spoken over the last 90 days, you would be moving to the top of the list. So we have 3 speakers tonight. Inglewood residents must provide their addresses or the cross street. Non-Inglewood residents must provide the name of their city. If you do have written materials, you may submit them to the city clerk in advance or at the meeting. Audiovisual materials must be submitted to the city clerk by 5 p.m. on the Thursday prior to the meeting. And let's see here. Excuse me. We have Ms. Joan Glover, a District 1 resident, here to speak first. All right. Ms. Glover, come on down. All right, Ms. Glover, there should be like a little green star or something like that in order to get the mic to turn on. And when you are ready, you may begin.
Okay, I just wanted to come because it's real timely.
Do you mind speaking up to the mic?
Go ahead. It's very timely what happened over the weekend. I just thought I'd come to the meeting tonight to let everybody know. There were some dogs that were in a car, and they were in that car for 20 hours before the police acted to remove those dogs from the vehicle. The police had said that they couldn't prove that the dogs had been in there since 4 o'clock on Friday afternoon, but in fact they could, because the people living in front of the vehicle had all of it on their Ring camera and had seen the person themselves. They'd actually seen the person park and walk away from the vehicle. I had walked by the vehicle at 9 o'clock Friday night, heard the dogs barking, and if I would have lived close enough to hear them barking all night, which the people said they did, I would have called the police during the night. The following morning, they came to my mind, and I arrived at the scene at about 10:30. The dogs were still in the car. The people had called the police already. An officer had come out and decided they would try to reach the owner, called the owner. The person hung up. And at that point, the dogs had already been in the car for 15 hours. And the police continued, in my estimation, after calling and not getting calls back, not having an officer come out. We're just trying to get the situation to remedy itself. And the person did not come back to the vehicle until 2 o'clock, so the dogs would have been in there for 22 hours. My problem is this. There needs to be accountability for pet owners when they're treating their animals in that way. So the police not acting and just hoping that the guy comes back and the situation resolves itself is not going to teach that person that what the behavior they're exhibiting is not right. So I was stunned that the police department was just not taking any responsibility in this situation. If it wasn't for my ability to find Rita Russell and have her intervene, that's how the situation would have turned out. And that's not okay. I mean, why I came tonight is I would really like to I wanted everybody to know the situation. And I wanted to say thank you that the town is small enough that I was actually able to find somebody to intervene and take care of the situation. And I think we need an animal control person working again on the weekends. Whatever reason you cut them from the budget, please put them back on the weekends. The police don't want to deal with animals. They feel, I don't know what their situation is, but we need an animal control person because we have to watch out for our animals. And I'll just say really quickly, I am going to pursue, I sent you an email about a HART ordinance, which is a set of laws in Albuquerque that are tremendous, and I'd like to see those implemented in Inglewood.
Ms. Glover, thank you very much for your time. Your 3 minutes are up. Let me see if there's any questions from members of council. I don't, well, go ahead, Member Russell.
I'll make a comment later. Thank you
Okay.
for coming forward, and we'll talk about the animal control on the weekend. Thank you.
Sounds good. Ms. Glover, oh, go ahead, Member Bethel.
So was there police intervening at some point to open that vehicle and let the animals out, or did the owners come back?
At noon, because I was able to find Rita Russell and she was able to speak to the city manager, then the police were given the directive to remove the dogs from the vehicle. They're currently at the South Platte shelter, and it's my understanding they are going to get a ticket for animal abandonment in a vehicle, perhaps animal endangerment. And I mean, I could tell the animal control they were also barking all night, so they could get a nuisance ticket too, and then they'll have to pay a fine to get those dogs out of the shelter. You know, what's really key here is educating people so that they understand what they should and shouldn't do with animal care. You know, I don't want to just accuse this person of being a deadbeat or something like that, but if he is able to get and that was the problem of the police not acting quicker, because if he would have come back, he could have parked the car on a different block and then those animals would have been in there, like who knows, you know, or he could have done it next month and then those animals
Mayor.
might have died.
Yes, Member Ward.
The question's been asked and answered.
Okay. I think, Ms. Glover, I think we're good on the
Okay,
answer there.
sorry.
So.
Ms.
Is there anything
Glover.
else, Mr. Bethel? Go ahead.
Yeah, Ms. Glover, thank you so much for what you did. Thank you for stepping in, for stepping up, and for looking after those animals. That takes courage, and I really appreciate it.
Thank you for saying that, and thank you for your time.
Thank you, Ms. Glover. And just so you know, there's going to be a response by Mayor Pro Tem here after the 3 speakers. So thank you very much, Ms. Glover. Up next is Mr. Bill DeSimone, a District 2 resident.
Good evening.
Okay.
On
Go
my
ahead,
way,
Mr. DeSimone.
okay. Too loud? Oh, on my way down here, I went through down through the Inglewood just to see what was happening. And so, you guys want to tear down some buildings and put up new buildings? For what reason, I have no idea, other than you think you're going to get new retail in here. What you need to do is take the buildings that we have and revamp them, make them a little bit more, I guess, noticeable so that people would come down and make the area a little bit nicer than what it is. Right now, I think it's just kind of very blah. All the buildings look exactly alike. There's no variety. There's no nothing. And I mean, to spend all this money to tear all these buildings down and then turn around and you think you're going to get retail by putting up new buildings, I don't think that's going to happen. I really don't. And it's just a waste of money. I mean, you have to do something. I mean, we have to do something. I mean, I was at a meeting the other night at Councilman Russell's town hall, and there was a lot of people, and they showed all these drawings and everything of all these fancy sidewalks and all these trees and all this stuff. That is not going to bring in retail. I'm sorry. It's just not. You need to have something down here to bring the people in. And I don't shop here. I don't shop at Inglewood at all. I I've lived here, lived in Inglewood now for 52 years. I do not shop here. There's nothing here that brings me to here. You need to renovate these buildings, get them, they should look at, excuse me, better looking than what they are. They're just very plain, very nothing. There's nothing there that attracts anybody as far as I'm concerned. So,
Anything else, Mr. DeSimone?
huh?
Anything else?
No, I just feel that tearing something down that doesn't need to be torn down is kind of ridiculous.
Okay. Mr. DeSimone, thank you very much for your time tonight. Any questions for members of council? Seeing none, thank you very much for coming tonight.
Okay, thank you.
And final speaker tonight is Mr. Benjamin Ben David, a District 1 resident. I'm going to say I didn't think I saw him in the crowd. No? Is he online?
He signed up a couple weeks ago, so
Okay.
perhaps something came up and he just wasn't here tonight.
All right. So, yeah, I was looking around earlier and I just did not see him. All right. So no one online either. All right. With that, everyone, that concludes public comments. So Mayor Pro Tem, when you are ready, you may provide a response.
Thank you, Mayor, and thank you, Ms. Glover and Mr. DeSimone, for coming out and speaking tonight. And Ms. Glover, really appreciate you taking personal responsibility for that situation and seeing it through, calling council member and making sure the problem got taken care of. I really appreciate it. And hopefully we can be able to deal with these things in a more timely manner in the future. And on that, I just have a council request to staff to explain the situation, why the police didn't do anything, and what potential crimes were committed, how we can resolve these kind of things more quickly in the future. And then, Mr. DeSimone, appreciate your thoughts on the city center and concerns about redevelopment. I too would love to see if there's any way we can, keep some of the buildings, reutilize them. That would be great. Also recognizing that the developer who owns the property is trying to figure out how to maximize their use of the property, and sometimes their conclusion is the best bang for their buck is to tear down the buildings and build new ones. So I don't know how it's all going to come together, but we do want to see this area, kind of the usefulness of it maximized. And I think that's going to involve adding some more buildings, possibly getting some more dwelling units in the area, so there are more people to activate the area. And then, of course, possibly, some larger attractive kind of thing as well to the area. So I understand the concerns about it and do hope that we can keep some of the really useful buildings in the area. But ultimately, I do think the area is going to need some significant redevelopment in order to be useful. But I appreciate your thoughts on it, and hopefully we can continue to gather feedback like that from citizens as a whole. So that's all I have, Mayor.
Thank you very much, Mayor Pro Tem. Member Russell, was there anything you wanted to add? I just had a couple things, so go ahead.
I don't know if we should do a council request on having animal control on the weekends, or what we need to do about that.
Yeah, I think that should be, I guess that should be a council request, whether or not we do have animal control operating weekends, and see if there's an opportunity. If not, find an opportunity to get them working the weekends as well. I think that we can add that in with your council request, Mayor Pro Tem. Just real quick, just because Ms. Glover, you're still in the room. Ms. Glover, you did provide me the hard ordinance within Albuquerque. So just as an FYI, I think City Attorney Niles, if you're able to send that ordinance to all of members of council, but just for your information, Ms. Glover, I did ask the City Attorney to take a look at the ordinance, find out what is already covered by either the City of Inglewood or the State of Colorado, what gaps still exist, and then from there, we'll figure out whether or not that's something that we should be adding as part of an ordinance here in Inglewood as well, whether through us or through our Code Compliance Advisory Committee or whatever their name happens to be at this time. But I do appreciate you putting that information or sending that information to me, Ms. Glover. So just wanted to let you know that action has been taken. All right. I see no further questions for members of council. So with that, everyone, we are now moving to consent agenda items. Let's see here. There were 2 items pulled from consent agenda items. I pulled 9A2, and we also received an email that the Dartmouth Bridge change order should not have been on consent, so that was 9C1. Any other items that should be pulled tonight?
Mayor, can I pull 9B5? It's just a quick question. I already talked to the city clerk about it. and-
9B5,
Yes.
yes, I can do that.
Thank you.
All right, so with that, everyone, can I get a motion to approve 9A1 and 3, 9B1, 2, 3, and 4?
So moved.
Thank you, Mayor Pro Tem. Could I get a second?
Second.
Thank you, Member Prang. Can we please vote?
Mayor Pro Tem Anderson,
Aye.
Member Bethel,
Aye.
Member Prang,
Aye.
Member Russell,
Aye.
Member Ward,
Aye.
Mayor Sierra.
Aye.
Let the record show 6 ayes.
Perfect. Moving on to 9A2, we have our Chief of Police, Dave Jackson. This item's data sharing agreement between the Colorado Bureau of Investigation and the Inglewood Police Department. Chief Jackson, I guess my question was, how is this information being used and who is using this information?
Yeah, it's a great question, and thank you for the opportunity to clarify. This is a one-way agreement. This is the Colorado Bureau of Investigation publishes what they call a hot list. That is a list of vehicles that maybe there's a missing person, a stolen car, those types of things. We receive that 2 times a day. It's updated frequently, but not in real time. I would say that mostly this is stolen cars, so that the license plate is in there. This would equip our new body cameras and in-car cameras to get that hot list information and run license plates. It's a one-way. This is not a data sharing per se. This is an agreement that we already have in place with CBI to receive that information.
Thank you, Chief. So just one way, nothing is shared the other way with CBI or with the federal government.
Correct.
Okay.
Certainly not with federal or anything like that.
Member Prang and then Member Russell.
Okay. Thank you for being here to answer questions. So I do have a handful of questions, but I also am wondering if we can delay this action until after we've had the conversation next Monday in study session, when we get better informed on data and systems and its usage. I do understand that it presents as a one-way agreement. However, it is an agreement to share data within the Axon system, which is a much larger database.
No, that's incorrect. No, the data is ours and ours alone.
Okay, but
the Axon is what reads it. The Axon product reads it for us, but it's kind of a pass-through, if you will. There's no data collected or stored outside of the Inglewood purview.
But the data flows through Axon, and so does it then get captured within the, I forget what it's called, Axon evidence, or I know it's a new name now. I forget the new name of it.
Right, I know what you're talking about, but yes, it is stored, but it's stored with the Inglewood in the Inglewood cloud. We have the
so we
only have the
data.
access to that data.
I think that this is why I would like to have this tabled, because there's just a lot here. For me, it's
Yeah.
I know that it seems really simple to you. However, I feel like there are multiple systems at play here. And so for us to have a better understanding of how those systems play together, and I do believe that there are some concerns that Axon has made claims, that even though the data is belonged by jurisdictions, that they're kind of like absent from having to take responsibility for the protections of those data, even though all of the systems should be encrypted and, all of the right things should be happening. So is there an extreme urgency on getting this executed right now, where we wouldn't be able to wait until after next Monday's conversation to have a more thorough understanding of the systems?
So we go live with this program April 1st. So next week is March 9th. Let me just clarify, when you were saying this is confusing, I was agreeing with you.
Okay.
Yes, no,
yeah.
that was not.
Yeah, I mean, there's just so many different systems and acronyms and whatever, and I was kind of doing some research on the various pieces of it, and I just think we have a responsibility to have that more thorough conversation. And I know you've been given some more information that, council would like to hear in that discussion. The public is paying closer and closer attention to data and privacy and securing all of that. So I just think that we have a responsibility to understand more holistically what we're looking at before we take this particular action.
No, I appreciate the sentiment, and I think that I'll just say from the police department's perspective, I want to do everything I can to keep Inglewood as safe as humanly possible within the confines of the Constitution, state laws,
Yes.
and all of those other protections. And I appreciate the opportunity to work through it. I agree with you. It is.
And I
a
believe in the
complex-
comment that you just made. I believe that that is your intention, and I appreciate you making that statement out loud. And I still think that we have a responsibility to have the conversation.
Totally understand.
Thank you, Chief. Member Russell?
Thank you, and I appreciate Councilmember Prang's direction totally, because that was more about the system, I believe. My question is, the police department has had a long-standing relationship with CBI for this information. Is that correct?
Correct.
Okay, and so anyway, but I do have some concerns about some of the software issues that you brought up earlier, so I appreciate that. Thank you very much.
So, Chief, if I'm understanding correctly, there's no urgency to have this vote tonight. We can have the vote in 2 weeks on the 16th after the 9th. Is that correct?
I guess I would maybe defer to legal live. We go live with this on April 1st is when we start with this. So I'm not really sure.
Where you start with Axon, or where you
Correct.
start? Okay. So then, if we don't have this data sharing agreement, it looks like second reading. If we were to have second reading, it wouldn't happen until April 5th, or whatever the date is. Is it the 6th? So then, would we?
Thank you. I guess I would clarify that is for the functionality of the license plate reading, as opposed to not being able to use the body cameras and other aspects of that. But yes,
Right.
that
Okay.
yes, it would delay the activation of that, I guess you could say.
By okay.
that
Well, in
aspect
worst
of it.
case, then if all's good next week, then we can make it a special meeting on the 23rd in order to make sure that functionality is available if needed this month in order for there not to be a drop. So there's ways that we can do this where we don't delay this aspect, but there are data concerns that we need to first understand.
Completely
Okay.
understand.
All right, Member Ward, go ahead.
Yeah, just wanted to thank Member Prang for bringing this forward. I too have some concerns in the modern environment with data going here and data going there. And so I would like to talk a little more about what the nuts and bolts. I don't usually look under the hood, but in this case, I think that would be an important thing to do. And I also wanted to point out, Chief, I appreciate your comments on keeping the city safe within the confines of the Constitution. I don't necessarily view this as a constitutional question per se, right? I'm driving my car, it has a license plate number on it, I've registered my vehicle in my name, I go from place to place, my license plate is in plain view. Whoever happens to take a picture of it with machine or in person has the right to do it because it's in open public view. The question is when government gets involved in that process, and then there's a data exchange between government and a private contractor, and where that data goes from there, and who benefits in what way. And that's, I think, largely captures some of my concerns here, is that I really want ironclad control at the current moment over what we are sharing and what we are collecting. Because I think there's some very real concerns that as the scope of that expands, the opportunity for other agencies who we believe would be otherwise acting in good faith to misuse that information. So that's where I'm coming from on it. Thank you.
May I ask a clarifying question to some of the comments up here? But besides a contract or an MOU or something like that, what assurances would the council like to see to, I'll say, control the data or control the dissemination of that? open for suggestion there.
Go ahead, Member Pring.
And maybe if you want to wait till next week, or I'm not sure.
I'm not sure that we have the answer to that, and that's why we need to have the conversation.
No, I
mean,
appreciate.
The more I learn, so the more I read this particular agreement, and there was, it does a great job of laying out some of the acronyms, and so I'm learning what all of the various pieces of the system are. So that's super helpful, and then I also go and start looking at other information to get more informed, and I just have more questions. And so for me, it is more of a matter of like how all the pieces play together. And I did appreciate in this agreement that it's got, an addendum and some, in one of the appendices, there's, certifications that people sign, et cetera. And I think that'll be part of our conversation, but we're not the experts, which is why we asked to have the conversation with our experts to be able to better understand what all are we using, what does it collect, how does it get stored, are we encrypting things properly, how does one system talk to another, and who's accessing it, how and why. I think having more of those answers helps us better know what to ask if we need to ask anything further, but then also just have more trust in the systems and how they're connecting to one another. I think it's kind of a prime time right now where people are asking a lot of questions around this. And so the more that we have a willingness and transparency to have the conversations that need to be had, I just think that serves the whole better. And in my humble opinion, brings more trust to your department and the actions that you do have to take and all of the great things that you do to keep our residents safe and our data safe, et cetera. But we just don't, without having the conversation, we don't know.
Thank you, Member.
I actually couldn't have said it better. So thank you. I agree.
Member Ward, you got something to add as well?
Yeah, I think for me, as I look through the contract, one of the sort of red flags that leaves some questions unanswered for me is in section 13, general provisions. If you look at letters H and I in that section, one of them is legal requests in regards to requests for the data that come from agencies, court orders, or court requests. And I is a specific clause related to court requests. And the question I have is, if we aren't actually collecting the data, what would we have to respond to in a court request? So I think the fact that CBI thinks that we need a CORA clause indicates that there may be some collection here outside of what we are anticipating.
Thank you, Member Ward. I'll add to it as well. I think for me is exactly how the information is being used by the federal government. Within the addendum itself, one of the things that gave me concern was the fact that if you look at the security violations, it says here that the FBI reserves the right to investigate or decline to investigate any report or unauthorized use. They kind of give a little bit more information about what that process looks like, but they're ultimately the ones that do any type of audits when there is a security violations. And obviously with the fact that we did a proclamation a couple weeks back, where we aren't completely comfortable with how the federal government is utilizing data and some of the steps that they're taking to follow the law, to me, this is almost like a fox in the hen house type of situation where we're providing information that we're not completely trusting of how it's being used. So when we speak about this next week, I want to understand the parameters of how that information is being stored, how it's being accessed, and if it's being able to, because I think with flock cameras, we were talking about like other jurisdictions around the area have the ability to view that information as well. Just in that example. But how do they access the information? Do we get notified that it gets used? How do we know that that jurisdiction is not providing that information to another jurisdiction that doesn't have login credentials? So those are the kind of the questions I have about this whole thing. So that's going to be some of the questions that I ask next Monday about this situation.
Understood. And I would just clarify that tonight, what this IGA between CBI and the Inglewood Police Department has nothing to do with flock. That's a completely different platform.
But it has to do with data, though. It's the underlying data. So it's not necessarily flock or Axon. It is data and how it's being captured and used by other entities. It's mostly that. All right. So I think there is a at least support to table this item until the 16th, based on just conversations tonight. So can I get a motion to table this? Let me see, what item are we on? 9A2 to March 16th.
Move to table 9A, what did you say it was?
9A2.
To March 16th.
Thank you, Member Praying. Can I get a second?
Second.
Thank you, Mayor Pro Tem. Any further comments from council? All right, seeing none, can we please vote?
Mayor Pro Tem Anderson,
Aye.
Member Bethel,
Aye.
Member Praying,
Aye.
Member Russell,
Aye.
Member Ward,
Aye.
Mayor Sierra.
Aye.
Let the record show 6 ayes.
Chief, thank you so much.
Thank you.
Moving on to, let's see here, this is 9B5. Member Russell, you have a question for the city clerk regarding the April 7th special election, IGA.
Yes, thank you. And my question for the city clerk is who gathers the ballots and transports them to the voting center?
Yeah, so this is a special election being run by an outside election administrator, and so they will be the only ones collecting those ballots out of the box. We just have to enter an agreement with Arapahoe County because they own the ballot box.
Okay, and that's because we're in agreement with this company and they get the key and everything from
Yes,
the county.
only
correct?
that election administrator handles the ballot.
Okay, thank you.
Any further questions on 9B5? All right, seeing none, can I get a motion to approve 9B5?
I move to approve 9B5.
Thank you, Member Russell. Could I get a second? Come on now.
Second.
Thank you, Mayor Pro Tem. Any further comments? Seeing none, can we please vote?
Mayor Pro Tem Anderson,
Aye.
Member Bethel,
Aye.
Member Praying,
Aye.
Member Russell,
Aye.
Member Ward,
Aye.
Mayor Sierra.
Aye.
Let the record show 6 ayes.
Perfect. Thank you. Moving on to 9C1. I asked for this item not to be on consent agenda item. Probably, actually, I never gave a response on the reason why to City Manager. So we have Chief Engineer Kyle Branham here to talk about the Dartmouth Bridge change order to pay outstanding invoices. And Kyle, just the reason why I pulled this off, this was one of the items that came in front of us last week where we are still awaiting a response on the $500,000 that we haven't paid one of the vendors. I wanted to just understand if any of these vendors that we are paying for these outstanding invoices are for the item that we haven't paid as of yet because of just a dispute about the contract, I guess in a sense, or contract language. But go ahead, Kyle.
Yeah, thank you. Thank you for your question, Mayor. The invoices that we're paying for now is just to wrap up the contracts from the construction, and that will all be paid for with a budget supplemental that was approved in January for $70,000.
All right, and to my larger question that prevented this from being from consent agenda items, that is still ongoing. We haven't received a response regarding that action. Is that correct, Director or Kyle?
Thank you, Mayor, for the question. Victor Rochelle, Director of Public Works. That's correct. What we were talking about last week was basically a hold on public improvement funds or PIF funds for outstanding litigation discussion due to delays within the contract. Tonight's change order was approved in an earlier budget supplemental in January and is for items that the contractor, one, failed to invoice on that we caught. It was a traffic signal pole outlined in the document, as well as some erosion control and some traffic control, which are all legitimate expenses that are finally closing out outside of the discussion.
Appreciate that, Director Rochelle. Any further questions for members of council on 9C1? All right. Sounds good. All right. With that, can I get a motion to approve 9C1?
So moved.
Thank you, Mayor Pro Tem. Could I get a second?
Second.
Thank you, Member Bethel. Any further comments? All right. See none, can we please vote?
Mayor Pro Tem Anderson,
Aye.
Member Bethel,
Aye.
Member Praying,
Aye.
Member Russell,
Aye.
Member Ward,
Aye.
Mayor Sierra.
Aye.
Let the record show 6 ayes.
Thank you so much, Mr. Branham and Director Rochelle, on that information. No public hearing items for tonight. We are now moving on to 11A1. This is first reading of authorizing administrative fine for violations of business license. We have City Attorney Tamara Niles.
Thank you, Mayor. Okay. So this is an issue that we faced on several occasions, and I've discussed with a couple of you over the last year or so. But we license multiple businesses. They have to obtain a city license to run specific businesses. And what we've discovered is when most of those licensed businesses violate our code, our only resource is to give them a stern talking to. Because under municipal code, the two options we have for most businesses is suspend their license or revoke their license. And on some of these businesses, such as say trash collection, that would hurt our citizens more than it would hurt the business if we take away their license and not let them pick up our citizens' trash. So we looked at what are some options, what could we do to address this? Because it seems like we're missing a less serious tool to be able to address these violations. So here are all the businesses that we license, quite a few of them. But some of them we do provide for specific penalties. So these are the ones that municipal code says we can give them a fine if they violate it, and here's the amount. So, I mean, it's a handful, but as you can tell, we have a lot of businesses that we don't have any recourse in which to impose a fine. So this ordinance gives you an additional tool to be able to do that. It proposes that city staff may impose a $100 administrative fine for every violation of the business license, except for those that already have fines within their specific sections of code. So this could apply if, say, a trash collector picks up trash at 6 a.m. instead of 7. Or I just saw a recent council request in the Friday report about a contractor where the construction activities have repeatedly, or at least on more than one occasion, started before the time allowed under code. And that council request that you got on Friday says we've talked to the contractor. They've again assured that their subcontractor won't start until the required time that's required by code. But if city council would so like, the ordinance in front of you would authorize municipal staff to impose a $100 fine for every violation. So it's not going to hurt any business, but it's going to at least provide some sort of ramification, acknowledgement you violated our code, you owe the city a $100 administrative fine for doing that. Now, if they refuse to pay, then we could consider a stronger sanction that already exists in code. But we also included due process where they can appeal the imposition of the $100 fine if they don't think, A, they did it, some other fact would support not imposing it. We've written in there that the fine could be waived if appropriate based on the facts. It's a pretty simple ordinance compared to the ones I brought recently. So, but when I saw the Friday report council request, I thought, well, this is timely. I'll be able to use that one as an example. So I would welcome your questions.
All right. Thank you very much, City Attorney Niles. Any questions from members of council? Go ahead, Member Russell.
Thank you, and thank you for this. Under the financial implications, it says the city sends approximately 40 to 60 violation notices per year, the vast majority which are operating without a required license or to failure to renew a license. So can you walk me through the process if they don't have a license?
So it would be generally the same, unless it's one of the 5 licenses that we already have a larger fee. For everybody else, if we have noticed that they violated our code by operating without a license, they would receive our normal notice of violation that says you're operating without a license in violation of our code. Immediately cease and desist or get a license, and it would also impose the $100 administrative fine.
So if they don't have a license and they have to, and so we give them a notice of violation, normally, do we really have the jurisdiction over them? What if we tell them, we're going to fine you $100 and they don't pay it?
Well, in that case, we don't have the additional options of revoking or suspending their license. In that case, we could always go to municipal court. We could send it over to the municipal prosecutor, say we believe this person is violating our municipal code, and we request that you consider filing charges against them in municipal court, in which case the judge has authority to order them to appear and to then impose a criminal fine for the violation.
So, I mean, if most of them are that, doesn't it make sense if they, I mean, I suppose if you call them and tell them they're operating without a license, they need to get a license. If they do that, great. If they don't, and they don't cease and desist, then probably they should get a ticket, correct?
Yes, and that's what we do now currently. Or I don't have numbers on how many times we do that, but that would be the current process, whether this is adopted or not.
Okay, because are there any unintended consequences of this, which is what I'm asking? So like, if we fine them $100 and what if they don't pay?
So I would anticipate that we would send it to collections. We do contract with a collection agency to collect money out to the city. Under our code, if somebody owes money to the city and they don't pay it and we try to collect, then we can send it to the outside collector to try to collect it. So that would be one option. We could also prosecute them in municipal court, but again, we could revoke or suspend their license if they do hold a license.
Well, if they do hold a license, then we have authority over them, right? If they don't,
yes, theoretically.
Right.
But we've seen people, despite being warned multiple times to follow the requirements of their license, we do see repeat violators of those that we do license as well.
Mm-hmm. So, okay, I mean, as long as we have authority over them, but I would think if they're violating our law and operating without a license, they should get a ticket and they should go to court.
And my purpose in this is not for criminal sanction, it's for compliance. And the hope is, especially those people that are licensed but just keep starting a little too early, or that this is enough of a stick that they pay a little bit more attention to it and ensure they don't have future violations. That's really the goal.
Right. And I appreciate that and I agree with that piece totally. But when it said the vast majority of them are operating without a license, then that becomes a different problem, I think.
Mm-hmm.
So, all right, I appreciate that. Thank you.
Member Warden.
So we chose $100 flat, but the other examples that you have here are for highly regulated activities, which has a range. What accounted for the decision to choose a flat fee instead of a range?
So it does go up for additional offenses within 2 years.
Okay.
The way we wrote it. I chose $100 because this is something new. We've never done it before. So I thought $100 may be more palatable to council. Let's start low and see how it goes. It's something we can certainly revisit, but I thought our goal is compliance. It's not to penalize anybody. And maybe this is enough of a sting to promote compliance. If it's not, I'll be the first one to bring it back and suggest we raise it. But I'll tell you, the amount is completely up to council. It's an amount that I chose.
Yeah, I'm, obviously probably one of the more punitively oriented members of this body as far as noise violations are concerned. So admittedly an extreme case, but it seems to me like for a contractor who is not obeying the city's limitations on when construction activity can take place, for instance, one of the things that I would consider doing is just saying, well, you have to take tomorrow off. You don't get to work tomorrow, because that's going to cost him thousands of dollars and not $100. And whoever's in charge of that job site is either going to get fired or make sure that it never happens again, one or the other. I know that's extreme and we're not talking about doing that right now, but that's sort of the way I would be oriented. So when I look at the $100 fine, I think, I picture the guy who's in charge of the job site just opening up his wallet and handing a $100 bill to the cop and saying, go away.
Well, we do already have the authority to make them stop construction. We have the authority already to suspend a license for a temporary period. I know when you use the example of a large construction site, I can see some unintended consequences there. For example, maybe they're in the middle of a concrete pour.
Right.
And if we say you're not working tomorrow, possibly have to tear all that out and start over. So there could be more to it than that, but it is already a tool in our tool belt. We just felt like it was extreme for some of these, what seem to be more minor to me because I don't live next to the job site. I'm sure it's quite important to the people that live nearby.
Okay, thank you.
Any further questions from members of council? If not, can I get a motion to approve 11A1?
Move to approve 11A1.
Thank you, Member Prang. Can I get a second?
Second.
Thank you, Member Bethel. Any further comments on this item? All right, I'm in favor of this, City Attorney Niles. I understand the reasoning behind the $100 fine. I also wonder whether or not that was too low, whether or not this should be arranged, but I am fine with just keeping it there. And then obviously if we need more teeth or just a bigger punishment for other instances in the future, then I'll be happy for you to bring it back in front of us. But I think this is a good place to start. So I appreciate that, City Attorney Niles. All right, with that, can we please vote?
Mayor Pro Tem Anderson.
Aye.
Member Bethel.
Aye.
Member Prang.
Aye.
Member Russell.
I guess.
Member Ward.
Aye.
Mayor Sierra.
Aye.
Let the record show 6 ayes.
So there will be a second reading on this one, Member Russell. So there's, I know there's a lot of information there that was given. So that's true. So is that? Do you want me to leave it off just for this? Okay, let's leave it off of consent. Thank you. And with that, let's move on to 11C1. This is establishing City Attorney Settlement Authority and procedures for settlement of claims. Again, City Attorney Niles.
Okay. In 2021, City Council first considered a resolution authorizing me to settle claims against the city for a certain amount. Under charter, you have authority to do that. But when I started, you hadn't formalized any process. So I asked City Council to do that. Well, since, I'm sorry, it was Resolution 21, Series of 22. So it was in 22. And the majority of claims we receive now are higher than $10,000. That was an amount that I had requested because it can be kind of a negotiation point that if you settle, if you'll accept our offer of settlement for less than $10,000, I can get you a check. It doesn't need to go to City Council. So we were able to more swiftly resolve some of the smaller claims. But we've seen a lot of inflation, and most claims are simply higher than $10,000. So I discussed it with a council member, and we discussed that perhaps it was time to raise that. In some informal conversations with some of my city attorney colleagues, it did appear that I had by far the lowest settlement amount. Some are 10 times higher than that. However, I don't want that much authority because I do think City Council needs to be involved in a lot of these decisions. So I am proposing that City Council requests or consider raising that to $25,000 if the funds are budgeted and appropriated. Meaning we have to have the money, it has to be in a fund, and it has to be there for me to be able to settle claims. If that fund is exhausted, then no matter what this resolution says, I have to come to City Council to request it because we need to find the money to pay a settlement. I also discovered that there was some ambiguity in the process as to exactly, does the mayor sign the settlement agreement? And I'm more comfortable with the mayor signing the settlement agreement. So at least one person on City Council has advance notice of any settlements, even if it's within this authority. And I wanted to make it clear that City Council is notified of all settlements. Of course, you get a monthly legal report from me that does describe all of those, but I wanted to formalize that to make sure it's in writing and a directive to me to do that. Like the prior resolution, it excludes our costs of defending a claim, and that's not within the settlement amount because we have separate budget for defending cases or paying for experts to analyze claims and things like that. So that's unchanged from the prior resolution. But one thing I really wanted was clarification on how I request that authority. Currently, I either request it in an executive session or I contact each member of council individually and I'll let you know this is what I propose and let me know if any one of you want an executive session, in which case we have an executive session. So I wanted to formalize that a little bit because we didn't have anything in writing that said that's what I should be doing. And so it includes if any one council member requests executive session, that we will have an executive session and discuss it together. We also had referenced work comp claims, and so The settlement authority follows that resolution process for work comp claims. Like now, if someone was hurt on the job, we pay their medical bills for treatment. But it clarifies, and I believe the prior resolution did, that if we pay to settle a work comp claim, then that's a settlement that falls under this resolution as well.
Okay, since the mayor is having a coughing challenge, I'll go ahead and open it up for questions. Councilmember Russell.
Thank you. The one thing I do, I don't like this in the settlement authority section 3, where it does contacting each council member separately. I think that we do need to go into an executive session on all of them so that council is aware of that. And one of my concerns about raising this is if we increase the amount of authority, there's a potential of major errors by staff being hidden from the public, whose taxpayer dollars are used to pay for these settlements. And I just want us to be open and transparent as possible as we can with everything. And so that's where I am right now, but I definitely want us to do it in executive session.
Thank you very much, Member Russell. Member Ward.
When the city cuts a check based on a settlement agreement with someone, that settlement agreement and the amount that we settled for becomes public record that is eligible for release under CORA. Is that correct?
That's correct. In fact, we just received a recent CORA request for a settlement agreement, which we produced.
So we can discuss tonight, as part of this discussion, some examples of settlements that you may have authorized during the course of your employment at that $10,000 level. Do you have some examples that you can give us of the frequent types of claims that might be justified, but are easily handled at your current level of settlement authority?
So I don't want to give away, yes, I can share those. I don't want to give away our maybe negotiating position. So I'm not going to give too much detail, but I can think of one in particular that it was an employee issue, and it was right before the holidays, and council was gone for its break. And our litigation assessment indicated that their claim was quite valuable. But I spoke to them and I said, council's on their break. It's right before the holidays. I can give you $10,000 and I can get it to you in 3 days. And even though we were at risk of quite a bit more, and so we were able to settle that. It was kind of an ADA accommodation claim.
What about something like a pothole?
We tend not to pay pothole claims. And it's because we're not liable for them. So we have paid some pothole claims. And we are liable if the city knows or should have known about the defect, but did nothing about it. Which it doesn't happen very often because our staff is very diligent and we have a pavement inspection process. So that we regularly check pavement and then fix it and repair it. So council has given me the directive that if we owe money, if we did something and we owe somebody money, to settle it swiftly and get that person their money. But if we don't owe the money, then I have a duty to protect city funds and to protect taxpayer funds. So don't pay frivolous claims. Even though it will take staff time to fight it, that we owe a duty to our taxpayers to protect their money, and so we fight it. So when we get a pothole claim that we don't owe, we don't pay it.
And I'll posit one more example that I believe I have seen, excuse me, on the list of settlements in the past, which would be an example where a city employee operating a city vehicle makes a very clear incorrect decision in traffic and causes damage to someone else's vehicle at an amount less than $10,000.
Yes, that I would say is probably the most common occurrence that we do pay damage claims out on.
All right. And so I guess my last question is in regards to this change from 10,000 to 25,000. Is this essentially just to account for the inflation that we've seen in the current market, where the currently justifiable claim tends to exceed $10,000 but may still be under the $25,000?
Yes, exactly. Especially those vehicle damage claims. They tend to be much more expensive than they used to be.
Great, thank you.
Member Prank.
Thank you for the presentation. So I believe I heard you say that you, under this new authority, you would only be able to do it up to the amount that was budgeted in your budget. So how much does the city attorney's office typically budget for settlements annually?
It's actually in the risk management budget.
Oh, risk management.
And so it's for claims and deductibles. And it's quite a bit because it's also our insurance deductible that pays for defense costs in litigation. I don't have that budget in front of me. I think it's $300,000 total for both.
Okay.
And our deductible is $150,000 per claim. So it's designed to be 2 full deductibles. But I'll double check as soon as I'm done presenting and let council know.
Okay, yeah, that's helpful just to have a ballpark of that. And then how many on average would you say settlements does the city attorney's office make per year?
It feels like more because now that I've taken on risk management, now I see all of those vehicle damage claims that the city just used to pay out, but now we treat it like a settlement. I want to say it's 10 to 20 per year. But one thing that we realized though is that we didn't have any provision for me to settle a claim on behalf of the city. So of course, having an active police department, we often have wrongdoers damage our police vehicles. And so we occasionally have an insurance company say, I know you said it was 14,000, but we'll give you 13,000 and we'll get you the check in 3 days. They kind of use that same philosophy I do, that a bird in the hand is better than the uncertainty of trying to recover from an insured. And so this resolution also addresses that circumstance so that I do have the authority then to receive money and to discount a claim as well in exchange for a fast payment.
Okay. I appreciate your answer as well, not an exact science of what the numbers are, just to kind of give a sense of this isn't like excessive amounts of money that you can continue to tap into throughout the year, that it's a set amount of money each year that we're giving you authority to function within. Thank you.
All right, I'm not sure who had the next slide on the right-hand side. Mayor Pro Tem, we'll start with you.
Thank you. My question is on this question of excess authority. I like the idea of an executive session generally, but I'm wondering if there's a benefit to us from being able to act a little more quickly than wait until the next council meeting. Does that play into the calculus here? If you said, "Oh, I think we can settle this for 40,000 if we do it," if we get them the settlement tomorrow, does that play into the calculus?
It does. We do, especially if someone's represented by counsel. This happened recently where they gave us a 3-day deadline to accept their settlement offer. And in that one, it was our insurer's money. But if we were required to schedule a special meeting and have an executive session, we wouldn't be able to accept within that timeline. But usually those timelines are very arbitrary as well, and we can extend them. So it's kind of a bit of a negotiation game that I somewhat enjoy.
Okay, thank you.
Member Bethel.
Thank you for the presentation. I appreciate you putting this together. My question is going to call for a little bit of your creativity, but you said that you use that $10,000 mark to use as a negotiation tool to say this is the limit before we bring it to council. If that increases to 25, do you think that the average level of payment will go up?
There's the potential for that, yes, because it's public what my settlement authority is. But I think it's only been the one example I gave that I was actually able to leverage that. So this is the reason I was hesitant, and I haven't requested it be changed in 4 years because of that. I wanted to keep it low to for a negotiating point, I suppose. But also, when we owe people money, we want to pay it quickly. We don't want to make them wait. And so that's what finally balanced the scale for me, is trying to do right by those people that we do owe money to, that we did damage their car, or I don't want them to have to wait for maybe an executive session for city council when I can say, I'm so sorry that we hit your car. We have your estimate. Here's the check for $12,000 after they sign a release, something like that. It's a balance, though, and completely within council's discretion. If you're not comfortable raising it, I completely understand.
Okay, thank you.
All right. Any further questions from members of council? All right. Seeing none, can I get a motion to approve 11C1?
So moved.
Thank you, Member Ward. Can I get a second?
Second.
Thank you, Mayor Pro Tem. Any further comments? Go ahead, Member Ward.
I'll just say that my vote tonight is going to be informed by my confidence in your ability to manage these settlements effectively. So thank you very much for stewarding the city's money and protecting our legal interests on a day-to-day basis.
Thank you very much, Member Ward. I too will be in support of this. City Attorney Niles, you do a great job of keeping us informed about any pending litigation, and so I have the confidence that you will continue to do that, regardless of what the dollar amount is. So I think with that, I would be happy to support the increase of the dollar amount for settling claims. So thank you so much, City Attorney. Go ahead, Member Russell.
And it is not any question in your ability to do the right thing that in asking these questions. I do have one question, though. Could we make an amendment to require an executive session rather than just contacting 4 council members individually? Because we're talking about taxpayer money, and I would like to entertain that.
So, excuse me, Member Russell, so you're asking for
An amendment to the ordinance, and it would be section 3, settlement authority in excess of staff's authority, but there's a clause in there. The city attorney may request and receive settlement authority by either contacting each council member individually to request authority and proceeding to settlement with approval, or otherwise failure to object to settlement by a minimum of 4 council members, or 2, in the city attorney's discretion or at the request of any council member, scheduling an executive session with all of city council to discuss the matter. So it would just be removing the first one.
Thank you, Member Russell. So there's a motion on the table to require the executive session. Is there a second? Members of council?
I don't know that I moved. I
You're
was just asking.
Okay. Thank you, Member Russell.
I mean, I'll make a motion and then we can talk about it.
Okay, go ahead, Member Russell.
I would like to move that we would amend section 3 by removing paragraph 1 or number 1.
And the first sentence, I believe,
Yeah.
right? Yeah. Is there a second on this for members of council?
I'll second exclusively for the purpose of discussion.
All right, thank you, Member Ward. All right, any further discussion on the item? Go ahead, Member Bethel, and then Member Ward.
I don't think this is a necessary amendment. In this section, it says that any council member can call for that executive session. So if it were a contentious issue, any member that was called to approve that funding in excess of the $25,000 would be able to call for the executive session. I think that's enough of a redundancy to satisfy my concerns.
Member Ward?
I concur with Member Bethel. There have been times when the city attorney has contacted us in regards to a settlement, and I have told her in my feedback, I would like to discuss this with the entire body. Because either there are occasions where it has struck me as so severe that perhaps our litigation position should be looser than it is, or perhaps it just upsets me, and I would like to have a discussion with the body about how we avoid something similar in the future and how much it's going to cost us to fix that problem. Secondarily, there are times when it is appropriate to cut the check as quickly as possible. And having to schedule an executive session prevents us from getting that money in the hands of the person who righteously deserves it in a timely manner. So I think it's nice to have the option there as it's written, but I don't think it is a requirement that we need to meet every time we're writing one of these checks.
Thank you, Member Ward. All right. Any further comments? If not, can I get, can we vote on the removing the first item from section 3?
Mayor Pro Tem Anderson,
Nay.
Member Bethel,
Nay.
Member Prang,
Nay.
Member Russell,
Aye.
Member Ward,
Nay.
Mayor Sierra.
Nay.
Let the record show 1 aye and 5 nays.
All right, thank you. With that, can we vote on the motion on the table for 11C1?
Actually, can I make a comment
Sure.
first?
Yeah, please do so.
Thank you for entertaining that and for the discussion. I greatly appreciate it. And I will be supporting this, so thank you very much.
Thank you very much, Member Russell. And with that, everyone, can we please vote?
Mayor Pro Tem Anderson,
Aye.
Member Bethel,
Aye.
Member Prang,
Aye.
Member Russell,
Aye.
Member Ward,
Aye.
Mayor Sierra.
Aye.
Let the record show 6 ayes.
All right, thank you so much, City Attorney Niles. All right, with that, everyone, good thing that I'm losing my voice here because now I got to read off this sentence regarding the executive session. So tonight, I move to go into executive session tonight. Excuse me, I move that council go into executive session for a conference with the city attorney for the purpose of receiving legal advice on specific legal questions under CRS section 246402 4B as follows: pending litigation and claims, council meetings, legislation and special projects and development, city attorney departmental operations. Present at the executive sessions are the following persons: Mayor Othaniel Sierra, Mayor Pro Tem Joe Anderson, council members Jack Bethel, Tina Prang, Rita Russell, and Stephen Ward, City Attorney Tamara Niles, and City Manager Sean Lewis. May I have a second?
Second.
Thank you, Member Prang. Can we please vote?
Mayor Pro Tem Anderson,
Aye.
Member Bethel,
Aye.
Member Prang,
Aye.
Member Russell,
Aye.
Member Ward,
Aye.
Mayor Sierra.
Aye.
Let the record show 6 ayes.
All right, we will now exit this meeting and reconvene in the community room next door. Thank you very much, everyone. All right, everyone. The time is now 9:44. Excuse me. And the executive session has been concluded. Present at the executive sessions were the following persons: Mayor Nathaniel Sierra, Mayor Pro Tem Joe Anderson, council members Jack Bethel, Tina Prang, Rita Russell, and Stephen Ward, City Attorney Tamara Niles, City Manager Sean Lewis. I move to close the executive session. May I have a second?
Mayor, can we make one clarification to the
Sure.
record? Councilwoman Russell left the executive session prior to the rest of us.
Thank you very much. Yes, just prior to the meeting ending. So thank you very much, Member Ward.
And if I'm going to make an objection, do we close it first and then I make the
I
objection?
think so. I think we have to vote first, and then at that point, City Attorney Niles, let me know if that's the proper procedure. I think it's after the vote, correct? Okay. All right. Thank you. All right. With that, can we please vote?
Mayor Pro Tem Anderson?
Actually, real
Wait,
quick,
did we get a
was it-
second?
Was
Yeah,
it? Yeah, I was gonna say, Member Prang, did you make the second or not? I thought so. I just didn't write it down. So thank you very much. All right. So Member Prang was the second. All right. With that, can we please vote?
Mayor Pro Tem Anderson?
Aye.
Member Bethel?
Aye.
Member Prang?
Aye.
Member Russell?
Aye.
Member Ward?
Aye.
Mayor Sierra?
Aye.
Let the record show 6 ayes.
All right. For the record, if any person who participated in the executive session believes that any substantial discussion of any matters not included in the motion to go into the executive session occurred during the executive session, or that any improper action occurred during the executive session in violation of the open meetings law, I would ask that you state your concern for the record. Go ahead, Member Russell.
Thank you. I would like to object because we talked about council policy regarding council disturbances and public comment. I objected 3 or 4 times in the meeting. I asked at one point to have the tape recorder turned back on, and I believe that that was out of bounds for the discussion because those involve public policy and our relationship with the public and openness and transparency. So I object for that reason.
Okay, thank you very much, Member Russell. All right. I think now we are get the other sheet of paper. I think we're going to Mayor's choice. So,
Excuse me,
yeah, go ahead, Member
I
Russell.
forgot something. So this section of the meeting, can we make sure to preserve
Yes.
in case someone wants to check into that? I'd appreciate that. Thank you. And then I am finished.
Okay, thank you very much, Member Russell. Yeah, I'll make sure City Attorney Niles will keep a copy. All right, go ahead, Member Bethel.
Is there security protocol in that packet, and is that security protocol part of the public record?
City Attorney Niles, I guess that would be a judgment by the city attorney in terms of whether or not there needs to be some sort of redaction or some type of what is able to be preserved as part of that document. So,
Yes, we will review it and complete that analysis and redact as necessary should anyone request the record under the Open Records Act.
Thank you.
Thank you, Member Bethel. Member Ward?
I would also suggest that the document may constitute work product, as it is not a complete document, and the complete document may or may not eventually be released to the public. And I'd like to thank Member Bethel for bringing this up. To the extent that there was discussion in the executive session, or there may have been discussion in the executive session outside the scope of attorney-client privilege, I would assert that the security discussion privilege applies separately. So I think that it was properly within the scope of the executive session privilege that's written into the open meetings law, and I do not believe that council acted inappropriately.
Thank you, Member Ward. All right, I'm just going to move on to Mayor's choice. I just have a few items. I wrote them down so I wouldn't forget, and now I can't figure out where I wrote them. So up first, just real quick, everyone, I have my traffic calming town hall coming up on Wednesday, March 11th. It's going to be down the hall in Hallett Hall. Is it Hallett Hall? Hampton Hall. In Hampton Hall, it's going to be from 5:30 to 7:30. There's going to be a presentation that starts like around 6 o'clock. Probably goes about 15 minutes, just giving the scope of what we're doing across the city. A big part of what we're going to be talking about, or at least that I'm hoping that gets covered, is just the fact that the Dartmouth traffic circles will be going in here in this year. So obviously, anybody that traverses across Downing as well as Logan on Dartmouth, I want people to be aware of what to expect, what they will look like, and that would be a part of the discussion, as well as other things that we have going on across the city regarding traffic calming. But I'll try to drop off flyers to people around the neighborhood on Downing before next week, so everybody's aware. But I've already published it online, and I know that the city's going to be doing their part as well to publish that. So that's one thing. Secondly, I want to also make people aware, like next week, our sister city from Belm, Germany, are going to be in attendance. They arrive on Sunday. They'll be spending next Monday here with City Council to give an overview of Belm, but they have activities with the school district as well as with our state representatives, and just taking in the sights of Inglewood, Denver, being chaperoned by members of our schools as well as the city. So looking forward to that. And they're returning the favor as we visited them last year. And then lastly, I know that this wasn't something that wanted to be announced by Mr. Parumba, but I wanted to just thank Mr. Parumba for his service to the city. His last day, I believe, is this coming Friday. I know that he wanted to keep it on the down low, but I just wanted to give my thanks to Mr. Parumba because he has been part of the whole city center redevelopment conversation since 2018 or so when he joined the city. And so without his input and without his work on this project, we wouldn't be where we are today. So Dan, really appreciate the service to the city. Thank you very much for everything that you've done to get City Center to the place it is today. So thank you so much, Dan. You'll be missed. With that, anybody with us, council member's choice? Go ahead, Member Pring.
Thank you. Just have one quick fun one. So I was invited by one of our candidates running for District 1, Rick Summerson, to attend an event that he held on BERT this last weekend, and it was really fun just to get on the vehicle and ride around the city. I've never ridden the route. We went several rounds, got off the bus, had some coffee, and just really had an opportunity to talk to all kinds of different people as to why they're riding the BERT and what they use it for, and a lot of really interesting conversation, especially around like how it really does, help fulfill a need of people who are, struggling with some affordability issues within the city. And met a couple from Oklahoma that's doing rehab at Craig, and just spoke so highly of our city, and they were hopping on the BERT to get around and have some independence as they were going through the rehab process. So just a really, really fun event, and I want to thank Mr. Summerson for the invitation.
Thank you very much, Member Pring. Anyone else? All right, City Manager's report.
Thank you, Mayor. Just two items. Thanks for mentioning the Belm delegation. One change from the original calendar invite that we sent out, and this has been changed on your calendar. Krista sent this out this week or late last week. We were originally going to have a dinner before council meeting next week, but the students, the high school students that we met with, said, no. Let's go to Moe's. Let's let them bowl. Let's have some barbecue. And then bring them to council. We thought that was a great idea, but we wanted to invite all of you. It should be on your calendar to join us for that welcome dinner. It's just going to be a little more casual. People can come and go, grab barbecue sandwiches, etc. But that's going to be on at 4:30 p.m. Bowling between 4 and 5. Food service starts around 4:45. And feel free to come and bowl and have some dinner and meet our German delegates. Then they come to council, and they'll be the first council agenda item, giving a presentation about Belm to you all. So they'll be introduced and then give a presentation. They sent me the presentation today. It'll be in your council packet that is sent out on Thursday. So thank you for that. Secondly, Member Ward made some comments last week about senior services and the need for those. In response to that, as well as with our active aging plan that's underway, we have been working with our consultant, Aging Dynamics, to create that active aging plan. and we're planning a study session on May 19th to go over that. So this will have a number of goals. First of all, an overview of the active aging plan. 2, engagement, including focus groups and surveys done to date. 3, resources and services provided by the city, along with Arapahoe County and the Regional Council on Aging. And we should have some partners there too. And then 4th, a presentation on the role of public safety agencies in supporting our active aging population. So after this check-in with council, we'll also be having a presentation this summer, likely in July or August, on the final draft of that plan. So just want to let you know that's coming in May, and we're trying to make that really robust in response to questions that we've gotten not only from Member Ward, but others as well. So glad to answer any questions about these or other issues.
All right. Any questions from council? All right. Thank you very much for that, Sean. All right. With that, everyone, this meeting is now adjourned. It's just before 10 o'clock. See you all next Monday. Have a good evening.